Am I audible now?
So,
Shall we start, sir?
yes, yes.
So, good afternoon, everyone. I, Pooja Dua, welcome you on behalf of Lawyer. So, today we have Advocate Ramana Reddy for the topic of how to respond to tax shoppers' notice. Ramana sir is a tax lawyer from Hyderabad and he practices on High Court and several other tax tribunals. His main area of practice is GST regime. He is the founder of Ramana Reddy Law. Ramana graduated from Gujarat National Law University in 2010 with BA LLB honors. After a short stint in litigation, Sir secured a JD from University of Toledo College of Law from Ohio, USA. At Toledo, he was the president of Regulus Society chapter. He moved back to India in 2013 and has been practicing law in Hyderabad since then. Since he focuses on tax, he regularly writes on burning issues in the tax space. Today, he will be talking about a few tips on how to respond to show cause notice from tax department. So you must have heard a lot of friends of ours who say that we have received show cause notice and we don't know how to respond to that. Today, Ramanda sir will be telling us a lot about how to respond to tax show cause notice.
Yeah, thanks, Pooja. Thanks for introducing me. Thanks, everyone, for joining in. Um, many years ago, I had attended a conference where the speaker had, so one of the speakers had come down to, during lunchtime, and he asked one of the attendees, because I mean, you're spending so much time at the conference, you're spending money to be here. What would be one or two things that would make this conference a success for you? And I remember the person who was attending the conference, he said, if I can take away one thing from the conference that I can use back, at the office or in my business, I will consider this conference a success. And I mean, that stuck with me ever since because, if you're not, if as a speaker, I mean, if any speaker is not able to deliver one thing that you can take back with you, that's not good. So the goal of this presentation will be, the spotlight. I'm just going to turn it on you, and the goal of this presentation will be to give you one thing, or at least a few things, hopefully, that you can take back and that you can use whenever you need or whenever you're working with the show cause notice. So, Pooja, can you go to the next slide? So let's assume that, I mean, suppose there's a T20 match going on between India and Australia, and an Australian player is doing the umpiring. Would you consider that fair? Probably not, because there is bias. I mean, how can an Australian player be an umpire in the game and then also be playing on one side? Now, when we put it like this is pretty obvious. But this is what happens in the tax system on a daily basis. There is inbuilt bias in the system. So, uh, so the way the entire tax system is structured, or the procedure is, the officer. So, suppose for the year, just for convenience, let's take the year 2000. Let's say for the year 2000, the officer gave you a show cause notice, and he said, look, you paid 5 rupees. I think you should have paid 10 rupees. So here's the show cause notice. And now you show cause as to why you should not pay 10 and why you should only pay 5. And you have a chance to file your written objections, you have a chance to get a personal hearing, uh, and then have an order face you. Now you would imagine that because so you are one party who's saying no, I have to pay 5 rupees. The tax officer is the other party saying no, you have to pay 10 rupees. So you would imagine both of you would go to a judge, and the judge would decide, okay, is it 5 or 10? But you would be wrong, because what happens is the tax officer himself decides if you are liable to pay 5 rupees or 10 rupees. Now, in administrative law, and even and which tax law is a part of, there is a fiction that is created that the officer is acting as a quasi judicial authority. So the same person is holding two different functions. But that is rarely the case. What we see most of the time is that whenever you receive a show cause notice, there is a high likelihood that the demand is going to be confirmed. So I think just when we are getting started with the entire process, it's important to have in mind that there is some bias that is inbuilt in the system that is against you. So anything you do, any communication that you send to the tax officer, that you need to keep this in mind. He's not just another party like in a civil suit where there's a land dispute. So this man is the party and the judge. So that's something to keep in mind. Pooja, can we go to the next slide, please? Now, whenever you receive a tax notice or whenever you receive a show cause notice, there are hundreds of things, there are hundreds of points that people could raise or that you could just go after. But I'm sure you've heard of the 80-20 principle, that 20% of what you do gives the 80% of the output. So 20% is the most important thing. So it's the way it is everywhere in all fields. 20% of people have 80% of the money, 20% of the seeds grow to 80% of the plants. This is called the Pareto principle. This is something cool that you can check out. So if you apply that analysis to tax law and just to tax litigation, no matter which tax lawyer you go to in the country, there are two or three things that they will look at before doing anything else. So if you receive a tax notice, these are the two or three things to do first before you do anything else. Let's imagine you're a law student when you just graduated. You're freshly a newly minted lawyer. You go to work with your boss, and your boss gives you a show cause notice to work on. Now, now, before you do anything else, these are the two or three things that you have to look at before you look at, before you open any book, before you go off in 1,000 different directions. Same thing if you're a businessman, you've received a show cause notice. This is so there are a few things that you'll have to look at. But the first thing that you'll have to look at is limitation. So limitation basically is, so let me just give you an example. Let's take the year 2000. Now it's been 20 years from the year 2000. We're in 2021 now. Now, if let's go the same dispute where you say, you file your returns and you say, I have to pay 5 rupees. The tax department says, no, you have to pay 10 rupees. Now, if they issue a show cause notice to you in 2021, asking for tax dues from the year 2000, that would be barred by limitation. So the department cannot do that because the law provides the department with fixed time frames. It says to the department, look, you cannot sleep over your rights for years and years together and then wake up one morning and say, look, that day you did not pay your tax, so therefore today I'm going to come after you. The law prescribes strict timelines as to when these notices can be issued. So take, for example, GST. Let's assume GST was enforced in the year 2000, just to go with the example. So if it was there in the year 2000, GST prescribes a limitation of 3 years. So at best, the officer could have given you a show cause notice or an order within 3 years. So that is by 2003. If he gives you a show cause notice or if he gives you an order after 2003, then you can just straight away say that it is barred by time and no case can be made out against you, regardless of how good this case is. mean, it really could be the truth that you did, that you had to pay 10 rupees instead of 5 rupees. But once they miss the bus, they will not be able to do anything about it. So whenever you're looking at a show cause notice, the first thing to ask is what is the assessment year? So if the assessment year, for example, is 2000, then you need to, add the number of years for, that the law prescribes, and ask yourself, is the show cause notice issued within that particular time or within that time frame? If it is issued within that time frame, the department is within its rights, and there's further analysis to be done, which we'll get into. But if it turns out that the department has missed the bus, then there's nothing anybody can do about it. So the first thing to look at always is limitation. And the law also prescribes, uh, so say, let's take the 3-year example, so 2002 to 2003. Now, under GST and even under old law, service tax, customs, excise, you take VAT. Under old law, there was a provision to uh, extend that 3 years to a 5-year period, but that is in very limited circumstances. So the thinking is, so let's say you say it's 5 rupees, the department says it's 10 rupees, and the department contends, look, you suppressed some very relevant facts, which is why we could not catch you in time. So this is something like you play fraud on the department or you suppress some crucial facts. Then the department is going to turn around and say, look, we need more time to, to find out what's actually happening. And for that reason, whenever they say that, or whenever the department makes out the case that there is some suppression on the part of the taxpayer, or some things that you should have disclosed, you did not disclose, and the department had to undertake further verification to find out that because let's assume you said 5, the department says 10. Of the 5 rupees, you didn't even show in your returns. The books are cooked up. Then the department will say, okay, look, we needed a longer time frame to to get the correct picture. But even if you play fraud, and this is again how important limitation is, even assuming that you play fraud, the department still gets only 5 years. So in the 6th year, if the department finds out that, look, you played fraud, we could not catch you, you have to pay 10 rupees, not 5 rupees. In the 6th year, the department cannot do anything about it. And there are different timelines that are prescribed under different legislations. So the Central Excise Act has one, the service tax has one, VAT, because it being a local enactment, has one. All of them are gone now. They're replaced by GST, but there's still some legacy litigation that is still pending. So if you receive a tax show cause notice, the first thing for you to do is to look at limitation. Pooja, can we go to the next slide, please? So let's assume that, going with the same example again, 2000 to 2003, the tax notice was issued in 2001. So you can't get them on limitation. Now you have to do further analysis to see if there is something else that you can do. Now, there is something called the principles of natural justice, and these principles are made by have been made by judges from centuries. And although these things are not usually put into law, into the statute or into the act, these things are read in because they're just such basic rules of fair play, of justice. So, so moving on one step. So you receive a show cause notice, you find out that it is within time. What happens next? So what happens next is you are offered a chance to file your reply to the show cause notice. So you are offered a chance to say why you think that you owe only 5 rupees and not 10 rupees. And the department will make out its case in the show cause notice. So that is a chance for you to put forth your contentions as to why it's only 5 rupees and not 10 rupees. And once you file your objections, the law requires that you should also be given a chance for a personal hearing. So the department is required to personally hear you and only then take a call as to whether you are liable for 10 rupees or not liable for 10 rupees. Well, like I said initially, there's a lot of bias in the system. So sometimes it could be an empty formality, but it is important that you file your objections and attend the personal hearing, and put forth all your contentions, make the best case possible uh, before the order is passed. Now, in this process with the show cause, the reply, the personal hearing, and the order, there are a lot of things that could go wrong. I mean, a few things that could go wrong, but they happen so frequently. I have at least seen 1,000 cases. I mean, not that I've done them personally, but I've done a few personally. When you just sit in court and you watch proceedings, there are so many of these cases that come up where there's a violation of principles of natural justice. So the first one would be where the order is passed without actually hearing you. So let's say a show cause notice is issued, and without waiting for you to file a reply, or without giving you a chance for a personal hearing, the officer passes the order. In that case, you can just bypass the entire appeal remedy, and you can ask me questions about that as to how that differs from the High Court. And you can just go to the High Court under writ jurisdiction and say, look, this is just basic principles of fair play that have been violated. I should be given a chance to put forth my contentions. I should be given a chance to put forth my contentions, both in the written form and in the oral format. And without that being done, no order can be passed against me. So if you receive an order without an opportunity for written and oral objections or a hearing, you can claim that there's a violation of principles of natural justice. Now, the other case is, uh, let's say that you run an industry, and the industry and the Department of Industries thinks that you have not paid your taxes, and it gives a report to the tax department. And based on that report, the officer comes to you and says you have to pay 10 rupees, not 5 rupees. And you say, and you file your objection, you file your reply, and he passes the order. Now, in that case, he would be okay if he had furnished a copy of the report to you, because it is important that you know what allegations are made against you in the report, uh, so that you can rebut whatever is there in the report. Without that, there's no way for you to know what allegations are made against you except what the tax officer is telling you. So if a report has been furnished behind your back by, say, one department to another, or even by a third party, a private party to the department, on the basis of which a show cause notice is issued to you or a tax order is issued to you, it is important that they furnish a copy of the report to you. The third one is bias. Now, this happens more rarely. This is a case where so you appear before Mr. X. He's the officer, and you put forth your objections. You do the personal hearing. An order is passed against you. Now you want to appeal that order because the officer disagrees with you, and he says you have to pay 10 rupees. Now you have the chance to appeal the order. Now, in some cases, what happens is that the Mr. X is now promoted as the appellate authority, and you now have to go and file an appeal before Mr. X himself, because now he's been promoted. Now that's a funny situation where the same person is sitting in appeal over his own order. Now, generally there is bias in the system, but that is such a clear-cut case of bias that we see, on its face. If you see a case where there's an order against you by the original officer or by the first officer or the lower authority, then you file an appeal, and the same officer sitting before as the appellate authority also, then you have a good case to say, this is just bias, and the order cannot stand. And the fourth one, like I just said, there are these bizarre cases where this happens, and this has been happening in Telangana now, where so for the year 2015-16, so just like you have, say 1999 to 2000 in the example, in the year 2015-16, under the central sales tax, because of the lockdown, the department was unable to function, and they were afraid that they would miss the bus with limitation. So what these people did was, basically, without issuing a show cause notice, they started issuing, I think, more than 400 to 500 orders were issued within Telangana. We were, without a show cause notice, without a personal hearing, without giving you a chance to put forth your case, the department just went ahead and passed orders. So, I mean, the High Court here has set aside more than 400, 500 orders, some of them in our own cases, where the court is categorically held, look, these are very, well-established principles. Uh, you need to give them a hearing before you do anything else. And these are just, and this is not an exhaustive list, but these are just some of the more common instances that we see, which is the violation of principles of natural justice. So, so again, just to recap, whenever you receive a tax or a show cause notice, or even an order for that matter, the first thing to see is, is it barred by time? Is it hit by limitation? If not, have you been provided adequate hearing? Have you been provided an opportunity to present your case? And only then do you move on to further analysis. Pooja, can we please move on to the next slide? Now the next one is, now moving on with the story here. So you receive a show cause notice, you file your written objection, you do your personal hearing, then you get an order that is against you, but the department says, no, look, you have to pay 10 rupees, not 5 rupees. Now you want to appeal that order. And tax legislations are very strict legislations, because because they take away your money, they take away your property, and it's very important to comply with them to the letter. So let's say there's a civil case, and you lose a civil case. Suppose it's a property case, you lose a civil suit, and you file an appeal, and suppose there's some delay in filing the appeal. Under Section 5 of the Limitation Act, you can file an application for condonation or delay, and judges usually entertain these applications, because the thinking is, look, let's not throw out somebody just because they're delayed by a month or two. Let's actually hear the matter. Let's do justice. Let's see who's right, who's wrong, and based on these merits, let's then pass orders. But that is not the case in tax legislation. In tax legislation, there are strict timelines that are prescribed as to when you can file an appeal. And if you miss the bus with that, then there's nothing anybody can do about it. So think of this like the flip side of limitation. So for limitation, if the department misses the bus, there's nothing that you can do about it. I mean, then nothing that the department can do about it. But the flip side is, if a tax order is decided against you, which it may most likely be, then in the appeal process, if you miss the bus in the appeal process, then it's very, very difficult to get or to even get the appeal numbered, let alone argued and filed. So just to take GST for example, so suppose you receive the order on the 1st of January 2020. You have 3 months. So, you have January, February, March. So by the end of March or by the 1st of April, you should have filed your appeal. Now there is a 1 month for condemnation. But you have to show really strong reasons as to why you could not file the appeal in 3 months. What prevented you from filing the appeal in 3 months? Uh, Now, if you miss the 4 month period, if you miss the 4 month mark, then really it becomes seriously an uphill task to to defend you, or to even defend yourself, because tax statutes prescribe a very strict timeline as to when appeals can be filed. Earlier, what we used to be able to do is, if you miss the bus here, you could have gone to the High Court, because the High Court is under the Constitution, not under the GST Act. And you could have said, look, I know I missed the bus. Here are some reasons. There are no facts really in dispute. Could you please consider taking up my case and hearing me out? But on a recent case called GlaxoSmithKline, the Supreme Court said that even the High Court should not usually entertain, cases where the party missed the bus in the appeal time. So once again, it's just very important to make sure that you file your appeal within time. Pooja, can we move on to the next slide, please? Now, again, this is just a tip. So if you have, say, 10 rupees as your output dues that you have to pay to the department, but you have, say, 5 rupees as credit, I would always recommend that you set off 5 rupees and 10 rupees and only pay 5 rupees. Don't pay 10 rupees and try to get a refund of 5 rupees. Because what happens then is, whenever you ask for a refund, you are basically asking money from the department. And we've seen cases where, you ask for a refund and the department comes and audits your entire company. And that is not a good position to be in. So whenever possible, always try to set off as much as possible and don't ask for a refund. But obviously, if you're in a case where you're exporting and you just have to ask for a refund, or if you have something called an inverted duty structure where the rate of inputs is higher than the rate of outputs, then no matter how much you adjust, you will always have some amount of credit left over. In that case, you can. But anyway, let's not worry about all that now. But whenever possible, always try to ask for always try to set off and don't ask for a refund. Pooja, can you please move to the next slide, please? Pooja, can you please? Yeah. That said, I just wanted to keep it short and crisp and just give you the few most important things to look for in a tax show cause notice or a tax show cause order. Also, I felt, talking for a long time may just violate everyone's basic human rights. So just to summarize, the first thing to look for when you receive a show cause notice is always look for limitation and whether the show cause notice or the order is barred by time. Then always ask yourself, was I provided adequate hearing? Was I given a chance to file my written objection? Was I given a chance to attend a personal hearing? And is there any bias? Was the same officer kind of promoted, and is he sitting in appeal over his own order? And what we've seen here, where the order and the show cause notice are the same date. I mean, if it is the same date, I have no idea how you could have possibly filed objections uh, and gone for a personal hearing. So anyway, so these are just some of the broad things to keep in mind whenever you receive a show cause notice. Before you do anything else, before you start looking at, well, am I actually liable to pay this money? Is the department right? Is the department wrong? Before you go to that, look for limitation, look for principles of natural justice, and that should that you'd be surprised how many cases are just covered by just these two aspects. And with that, I'd like to thank the lawyer team for having me over, and thank you for watching this.
Thank you so much, sir, for providing such good information to us. It was really helpful. I think it will be helpful to people who are watching this and who will watch this in future. Thank you so much, sir.
Thank you so much.